Good evening, friends. Today we'll be discussing on patent rights and law relating to the patents in India, including the Indian Patent Act 1970 and the Rules 2003 and other related national and international issues with respect to the patents that are granted the patent license. What is a patent? Patent is one of the privilege given to an industry or the individual based on the intellectual property which has a novelty, uniqueness and having the utility, and it should be a non-obviousness. In fact, all the intellectual properties, they are like any other property where the owner can claim the rights. With respect to the intellectual property, it starts with the idea and then to the expression, and ultimately it goes to the intangible to the tangible. Patent is related to the industry. In fact, the first convention on industry related activities in Paris Convention 1883, they have considered the patents as one of the intellectual property rights along with the trademark and other things. So now, based on various conventions, India becoming a part of the international forum with respect to the protection of the intellectual property rights. In 1970, Indian Patent Act was established and the relevant rules are given in 2003. In the Patent Act, it is very clearly mentioned what are the subject matters for the patent and what are the not. The one of the important thing and the criteria is it should be passing the principle of none, that is a novelty, utility and non-obviousness. And it should have a particular application capable of industrial application. This includes both the products and processes. Initially it was only the processes and gradually the products were also included through an amendment. And whatever the improvements made, if they also are they are also having the novelty, utility and non-obviousness, it can also be considered with the patent rights. But there are certain exclusions are there. Any patent, although meeting the criteria of NUN, it should not be any invention contrary to the public order or a morality or scientific principles or any methods of the agriculture, horticulture or any traditional knowledge. These are all non-patentable subjects. And the duration of the patents is 20 years from the date of the filing the application. It is not the date of the grant of the application. Grant of the application may take some 18 months, even sometimes more, but it is the date of the filing the application. The duration is 20 years. The process of the filing and examining the application, which includes one has to file the application in Indian Patent Office, and there are provisions both for national and international application under the Patent Cooperation Treaty. The PCT, one of the important criteria in the PCT which is accepted by all the member countries is if patent application is filed in one country which is accepted, then the date of the filing is applicable to all other countries also, because if the patent has to be taken in one country, that may not be applicable in other countries, so one has to file in each and every country. But here the simple one of the facility given to the applicant is your date is protected. Once you file an application accepted in one country, that date is valid and you have a priority on that in other countries also, provided you file within the 12 months from the date of first application. So that anybody who files between these 12 months, still the first applicant will have the priority for the filing. And the patent has to go through an examination, and the examination includes its novelty and it involves the inventive or innovation and non-obviousness, and it should be capable of for industrial application and other utilities. The examiner checks for the compliance with other requirements of the acts and the rules before the application is accepted. Publication of the patent application. In India, typically published within 18 months after the filing date of the priority date, or whichever is applicable. Generally, applicants can request for the early publication also, depending on the other constraints, it can be accepted. And there is always a opportunity for those who wanted to oppose, so that once somebody's patent is not copied and filed application. So for which there is a time given after publication, all the third parties are given the opportunity to oppose within a specific period. The specific period will be determined by the patent granting office. And once the all objections are taken into the consideration based on the grounds, the patent office will decide on the eligibility of the patent application acceptance. In case of a patent, there is also a compulsory licensing is there. Compulsory license means although somebody has got a patentship who can continue with this patent, others are also permitted to do the same thing despite the fact that the patent is given to somebody. This is permitted only by the government and statutory bodies, subjected to certain requirements. It is not as simple that one patent is granted then immediately others are granted the license. No, it is something like, if compulsory licensing is required in the interest of the public, particularly with respect to some of the food related or some specific innovations that are required in the scientific research or the drugs, medical utilities. These are all some of the areas which are decided by the government or a statutory authority. And one of the reason also, if the patented item is very heavily priced, and to ensure that it is not so heavily priced, others are permitted so that public will get it at a reasonable price. These are some of the criteria is there for the compulsory licensing of the patentship. And once a patent is granted, the patent will have certain rights. Some of the rights, these are all the exclusive rights, which includes to create or make, use, sell and license their patent to invention. See, as a patent, compulsory license is given by the government, but the patent himself or herself, the organization itself, can grant the license to somebody in their own commercial and other interests, and it is their exclusive right. Because he has given the license to others, it cannot be made into the public and everybody cannot do that. See, they can take legal action for anybody who infringes the patent rights. And working of the patents includes patent holder is required to work for the patented invention in India to the fullest extent possible, except some specific requirements are there due to experimental things which can be probably done in the other country, but this is the discretion of the Indian Patent Office. They will check up, is it a genuinely done in the India? Accordingly they decide. If any such thing which patent has not done in India but copied from other countries or resourced from other countries, then the authorities can make a compulsory license of such a patented product or a process. India has made agreements with several international agreements are there, and one of the most important agreement is the trade related aspects of the IPR. This is done under the administration of the World Trade Organization, WTO. India, being a member of this TRIPS agreement, has certain privileges and restrictions also. These are some of the issues with relation to a quick review of the patentship, and we also will have in this introduction a quick review of some of the case studies or case laws, a very quick titles, and we'll be discussing in detail in future sessions. See, it is a Novartis versus Union of India. This is related to a drug. Then Roche versus Cipla. This is with respect to the generic version of a particular, like how the infringement has taken place. Another case lies Bayer Corporation versus Union of India. This is particularly with respect to the affordability and general licensing. Another case is Ericsson versus Xiaomi. In this case, it is the essentials. What are the overstandard essentials, standard essentials? How the interim injection against Xiaomi was given by the court. These are all things are there in the Ericsson versus Xiaomi. Finally, another important is the Merck Sharp versus Domi Corporation. Merck Sharp and Domi Corporation versus Glenmark Pharmaceutical. See, in this the cases dealt with the patent infringement and the validity. So these are all some of the important case laws which we will be discussing in detail. But overall, this is a brief session on intellectual property rights with respect to the patent laws, that too in the context of the Indian laws. I hope this brief introduction has given you some information, and this is a channel that will bring all the technical and managerial issues and other general issues. If you like, please subscribe to this channel and also share to those who are interested in this subject. Thank you very much. Have a nice evening.